The federal government. Bankruptcy is federal law. And so that means that you have the federal government behind you when you go into bankruptcy. If there's a problem with a particular creditor, you can go before the judge and get sanctions. And sometimes those sanctions can be really quite large. On top of that, in many cases, you can get costs and attorney's fees, which is highly unusual in American jurisprudence. Generally, you only get costs and attorney's fees if either there's a pre-existing contractual right or there's an enabling statute. And an example of an enabling statute is in Section 362 of the Bankruptcy Code. That's the section dealing with the automatic stay. When you file a bankruptcy petition, just that act triggers a stay. You don't have to do anything else, which is called the automatic stay. The stay in law says stop. Whatever stayed has to stop immediately. And in this case, what stayed or stopped is all action by creditors against you as a person, against your possessions, and against the bankruptcy estate that's created when you file your petition. In practical terms, it means they can't even contact you. They can't call you on the telephone, send you bills, write you letters, sue you, garnish wages, seize money out of bank accounts. If they've been doing any of those things, they must come to a screeching halt. And if a creditor violates the stay after it's received clear notice of your bankruptcy petition, you can sue it in the bankruptcy court. And if you're successful, as I said, you can get costs and attorney's fees because Section 362 does give costs and attorney's fees to an injured person who is injured by the violation of the automatic stay. So just there, all by itself, there's a pretty good solid cudgel. And you might even find a contumacious creditor that says, well, I don't care about that stuff. Well, I had that happen a few years ago where I got sanctions against a creditor and the creditor refused to pay. So I contacted the Office of the U.S. Trustee, and they contacted that creditor, and that was really quite an effective way to force the creditor to disgorge the money. So there, on a very personal level, I was able to get the U.S. Trustee to help out and get the sanctions that had been awarded by the judge. Point here is you've got the federal government behind you. With debt negotiation programs, debt settlement companies, you don't have anything other than perhaps the eloquence of the person that's going to negotiate with the creditors. But these creditors generally are not populated by idiots. You might not like them, you might not like the fact that you owe them money, but they are not populated by idiots. And so they've seen this kind of thing before. And you might not get very far if you're going to try and pull a fast one.